The term expert determination is normally used when describing a process through which a disputed issue is resolved by an expert rather than by courts or an arbitral tribunal. Further, across jurisdictions, the term expert determination is typically used when talking about binding determination. In theory, expert determinations can be binding or non-binding. However, if the parties agree to obtain a non-binding expert determination, the results are only likely to be something which the parties might bear in mind in the context of a mediation or some sort of negotiated settlement. Since expert determinations are normally conducted by subject matter experts and not by judges or arbitrators, they are typically reserved for narrow technical issues, and they are not used for broader disputes which might incorporate legal issues, such as the scope of a particular statute or the interpretation of a particular clause of a contract.
In an increasingly interdependent world, an improved legal framework to facilitate international trade and investment serves to enhance predictability and business confidence. As the core legal body of the United Nations system in the field of international trade law, UNCITRAL continuously strengthens the international commercial framework through the adoption of various harmonizing instruments. These are negotiated with universal participation from member states of the United Nations, as well as international, intergovernmental, and non-governmental organizations with relevant value added. Over the last 50 years, UNCITRAL instruments have bridged the gap between the civil law and the common law, as well as Islamic law, and we stand ready to continue to do so in any areas of international trade law. As a result of UNCITRAL's inclusive process, UNCITRAL texts are widely accepted as offering solutions appropriate to different legal traditions and to countries at different stages of economic development.
What indeed is a truncated tribunal? In summary, a truncated tribunal is one where, in a tribunal of 3 arbitrators or 5 arbitrators, one arbitrator ceases to act as arbitrator for one reason or another, and the remaining arbitrators proceed with the arbitration in his absence. A truncated tribunal may occur for various reasons, namely death, resignation, successful challenge, or if for any other reason the arbitrator fails to attend the proceedings or deliberations, or to complete his work as required. The main issues which arise in this situation relate to the authority of such a truncated tribunal. Indeed, what is its authority? Will an award rendered by it be valid? Can such an award be potentially challenged? These issues have arisen frequently before arbitral tribunals and also before national courts at the stage of enforcement of arbitral outcomes.